Thank you, Anita. I appreciate that kind introduction. Today I'm going to be talking to you about Oracle licensing considerations, and we will be going over various components of Oracle licensing. I've prepared an agenda for the items that I'll be covering today. And as Anita mentioned, please feel free to include questions in your taskbar, and if I have an opportunity at the end of the presentation, I will be happy to address as many questions as I can. Today I'm going to be talking about different types of Oracle licenses, and one of the reasons that we thought it was important to have an opportunity to share a little bit about these types of licenses with the group is that I am seeing an increasing number of my clients who are working with Oracle, fighting with Oracle, and otherwise struggling to include and to interpret and to select Oracle licenses. And I'd like to try to identify some of those issues for the group today and also offer some opportunities for how to resolve some of those issues. During the discussion today, I'm going to talk about different types of Oracle licensing. About half of the struggle that I see from folks who are trying to come to me to solve Oracle questions really just have questions about how to license Oracle's products. And what my clients are finding is that it is becoming increasingly difficult for clients to get answers directly from Oracle on which those clients can rely. And so what will happen is a client will have a particular new use that the client wants to consider. The client is concerned after reading licensing documentation that contains sometimes contradictory and sometimes ambiguous information. And so the client will reach out to a reseller or to Oracle representatives directly to try to resolve some of these ambiguities or questions that the client may have about licensing Oracle products. And what the clients are finding these days is that it's difficult, if not impossible, to get an answer from Oracle. And if you do get the answer later in an audit situation, it may be the case that the answer isn't enforceable or reliable. And we'll talk about that a little bit more. But I'm seeing that as a challenge for licensing that many of my clients are facing. The second big issue that I see a lot is that Oracle acquires a company with whom my clients have had a long-standing relationship. So Siebel is a perfect example. Oracle acquires Siebel, and then after a time, Oracle changes the licensing metrics in such a way that it is even more confusing or difficult for my clients to adhere to the new licensing terms. And finally, Oracle is definitely increasing its audit presence. I've seen the nature of Oracle audits really change over the last 5 years. Many of my clients are faced with a lot of different surprises during the Oracle audit. We're going to go through some of those. And specifically, I wanted to call out the termination provision in the license document, because that termination provision often comes as a great surprise to my clients, but is typically used as a large weapon in Oracle's arsenal during the audit process. So it's certainly important for us to understand the termination provision, understand how everybody is getting confronted with this termination provision, and how you can potentially resolve those issues. So I'm going to go over some of those. Again, feel free to present any questions that you may have in the process, and I'll check periodically. So if you hear me pause a little bit, it's usually because I am going through and looking at potential questions to answer during the presentation. First of all, I want to start, as I mentioned, with an overview of the types of licensing. It is somewhat confusing to our clients that Oracle offers two different platforms of products. The first type of products Oracle offers are application products. The reason that it's important that they're divided into two categories is Oracle has different licensing regimes for the different types of products. So examples of application products include eBusiness Suite, JD Edwards, Primavera, Siebel, Oracle Application Server. Those tactical applications that clients are using to run and manage their businesses typically fall into the application category. The technology products are more like system integration, the cloud services, data center infrastructure solutions, application development, those types of products. So it is important, if you're trying to evaluate the licensing requirements of an Oracle product, you need to know which product family that particular product belongs to so that you can make sure that you're evaluating the appropriate licensing metrics for the different types of products. Oracle has a multitude of license types, but the ones that I typically see are the ones that are listed on the slide deck: the processor licenses, the user licenses, and the revenue-based licenses. The processor licenses are calculated using a combination of the number of cores or sockets that exist on the machine, the number of, and then you multiply it by Oracle's core processing licensing factor to come up with the number of processor licenses that you're required to use if you have that particular type of Oracle product installed. Oracle user licenses typically fall into the category of named user plus licenses, and many people run into trouble when they try to calculate the number of named users they're required to identify in their ordering documents or required to purchase in order to be compliant. And so we'll talk a little bit more about how to calculate user licenses in a moment. The revenue-based licenses are typically assigned to a particular line of business, and Oracle will say, you can use this particular product, but you have to pay us a certain number of dollars for every identified amount of revenue you earn. So you have to pay us $20 for every $40,000 in revenue. I find that many of my clients are struggling with revenue-based licenses, particularly when they have multiple lines of business that fall into the same category of licensing revenue according to Oracle. So for instance, a company may have a line of business that includes all shipping. So Oracle will say, you're required to pay us a licensing fee based on every bit of shipping revenue that you take in within a certain period of time, whether it be a quarter or a year. And then my client acquires another company, one that is not dependent on the Oracle technology to achieve its revenue goals, and that revenue Oracle wants to include in the total shipping revenue required for licensing. So how you treat acquisitions and divestitures, or how you treat lines of business that are either dependent on Oracle technology or independent of Oracle technology, can be a real challenge. I've seen over the last few years that Oracle is really making a push to convert many of its larger enterprise clients onto ULAs, or unlimited license agreements. For unlimited license agreements, there are many benefits, but there are also several big challenges that my customers are facing, and so I wanted to take an opportunity to discuss some of those challenges today as well. As I mentioned, one of the main types of Oracle licenses is Oracle processor licenses. It is very difficult for clients to manage these licenses, particularly in a virtualized environment. I have found that it is often a surprise to my clients that as a general proposition, licenses that are typically not licensable for other software publishers like Microsoft, and these would be development or testing or quality control, any Oracle applications that are being used for non-production purposes are typically still subject to the same licensing requirements. It gets very difficult for Oracle's customers to make sure that they are compliant with the licenses, particularly in situations where they're using virtualization technologies, especially ones that are not Oracle-approved virtualization technologies. Additionally, it is difficult for my clients to determine the value of licenses for those environments that are traditionally considered to be not licensable environments by other publishers. One of the challenges that many of Oracle's customers have is that Oracle requires the full power of a particular environment to be licensed in a virtualized environment unless the customer uses a specifically identified partitioning technology. So as many of you likely know, the importance of virtualization is to migrate any of the resources to the place where those resources will be used most efficiently and effectively. And if you install a particular Oracle application or a particular Oracle solution into an environment where it is able to migrate rapidly to take advantage of the most efficient opportunity for the use of those licenses, which is why many people want to virtualize those technologies, then Oracle wants you to pay for any available resource that could be available. And so in order to limit licensing fees, customers are required to do at least two things, and sometimes many more obstacles to overcome as well. But the two that are most important that Oracle will be looking for in the event of an audit is whether the customer used an appropriate hard partitioning technology to limit the resources available in the virtualized environment to a particular segment of that environment, to limit the number of licenses that are required. And you have to make sure that live migration is disabled so that the resources cannot be immediately accessed. That will limit the availability of those resources in the virtualized environment, but also limits the number of licenses that are required. So I think people can recognize that by requiring customers to license the full resources of a virtualized environment without these hard partitions and without disabling live migration could cause the environment to get very expensive very quickly. With respect to the license metrics that are based on the number of humans, and here I said humans in the presentation, but in many instances it's humans or devices, regardless of the name of the license. But today I want to just talk about the licensing metrics that are based on the number of people. I see a lot of companies struggling with named user plus licenses for a number of reasons. One of them is the definition of named user plus. The software publishers are increasingly identifying the definition of a named user, and Oracle is no different than the majority of the publishers on this issue, as any individual that's authorized to use the program. So in many instances, there are user groups or user communities that are configured in the platform and allowed to access the products and services that are available, and those users have never logged in, will never log in, don't know how to log in, wouldn't know how to use the product if they logged in, and have no legitimate business purpose for having an ability to access that license. In an Oracle audit, it won't matter. None of those items will matter. It will be required if there is a user set up in the system, even if they've never used it and even if they don't need it, it will be required that they purchase a license. So it is critically important when establishing the requirements for particular Oracle usage that current and near-term prospective future use is evaluated carefully, and that when the product is set up, that the product is set up in such a way that users who are not going to use the product are not inadvertently included into a user group. This can be even more difficult in the cases where clients hire consultants, including Oracle-based consultants, to deploy these products, because what happens is the consultants don't necessarily know who in the company needs to use the product, and so as a default, the consultant will set up the entire user community as users in the Oracle product, and then Oracle wants the client in the end to buy licenses for all of those potential or prospective users, which can be a problem. The other big issue that I see with respect to Named User Plus licenses are Oracle requires, and it's somewhat unusual in the industry, minimum numbers of users to be applied or acquired when you're using certain products. So for instance, Database Enterprise, and you'll see this example on your presentation, database Named User Plus licenses for the Enterprise Edition require 25 user licenses for every processor. And so first you have to determine the number of cores and then multiply it by the core factor to determine the number of processors. And then for each processor on the computer or computers that are running Database Enterprise, you have to buy 25 Named User Plus licenses, regardless of how many people are actually using the product. So Oracle's minimum requirements for Named User Plus, whether it be the Standard 1 edition or the Standard edition or the Database edition, all have minimums. They're not all tied necessarily to the number of processors, but it is important to make sure that you don't assume that you can just go and count the number of potential users you have. As an alternative, Oracle does offer sometimes the number of employees as a licensing metric. Again, in this case, it doesn't matter whether you're authorized to use the software, but whether you actually use the software. But in this case, it also doesn't matter whether you're authorized to use the software, because you have to get a license for every employee. This licensing metric is not a good idea unless it is absolutely clear that all employees will be using those particular licenses. As I mentioned, the revenue-based licenses are licenses that are based on the total amount of revenue that's attributable to a particular subsidiary or a particular line of business. And what folks are seeing is it's very difficult to determine the appropriate license value for whatever their licensing measurement is. Additionally, the license fees, sometimes the clients, when they are smaller or have less revenue, are okay with the way that the Oracle licenses work. But if the revenue is increasing substantially through no contribution of the Oracle products, the client becomes less excited about paying these revenue-based licenses. The biggest challenge to revenue-based licensing is those situations where the client is acquiring either new companies or new lines of business, or divesting itself from existing divisions, or lines of business, and those inclusions or divestitures are not taken into account necessarily unless revenue increases or decreases substantially. And so it is important, if a client of Oracle's is considering entering into a revenue-based license with Oracle, that the client is working with Oracle to identify the appropriate revenue metric or line of business metric to use for those particular licenses. I'm going to spend a little bit of time this morning on unlimited license agreements because I have seen both an increase of interest and several cycles now of the unlimited license agreements have been completed for many of my clients, and there are a number of different issues that keep popping up, and I think that this is one of the most popular issues that people like to discuss when they're considering Oracle transactions, and so I want to spend a little bit of time on this particular issue today. A typical term of an unlimited license agreement is 3 years. And so the way it works is Oracle picks a particular set of products that the customer should consider for an unlimited license. And then during the sales transaction process, Oracle will evaluate with the client's past use of these products that Oracle wants to include in the unlimited license agreement and the prospective future use of those products. So the customer and Oracle will get together, they'll talk about what they have now, what they might need going forward, how they're planning to use it, whether they're planning to grow. And so Oracle and the client will sit down and identify a limited subset of products in the Oracle portfolio to include in this particular unlimited license agreement. It is not unusual for my clients to have multiple ULAs at one time, and it is also not unusual for my client to have an Oracle licensing and services agreement, which is called an OLSA, and a ULA at the same time. So once Oracle and the customer agree on how they're going to include or exclude products from the ULA process, then Oracle will give the client a 3-year fixed price for the customer's use of the product. The customer agrees to pay that fixed price over the term, which, as I said, is usually 3 years. And then once the client pays the amount of money that's articulated in the ULA, the customer can use as much of that product as they want. At the expiration of the ULA, the customer then does an inventory or an analysis or an audit of its own environment, determines how much of the product it actually used during the term, and certifies the amount that was actually in use during the term. The Oracle agreement then says that the customer at that time gets a license to use all of those products going forward if the ULA is not renewed. And the support for the certified license quantity typically can't be reduced following the certification. So what happens is you as a customer will say, we need eBusiness Suite. We want a ULA for eBusiness Suite. At the end, we certify that we're using X number of licenses for eBusiness Suite. And 2 years from now, you decide you don't need all those licenses for eBusiness Suite anymore, and it's very expensive to continue to maintain the licenses. It's sometimes a challenge for Oracle to reduce those quantities of licenses without discontinuing maintenance on the entire platform. And so I have seen a lot of customers that are really struggling with the challenges that they found in certification for a ULA. The additional issue that I'm finding is that because the customer has spent 3 years using the products without having to count them, I have found that nobody knows how to count when the expiration of the period expires. So you've gone for many years where you are using the products, you don't have to count, and then you suddenly have to count, and people realize that they don't even know where these products are being used in the environment. They don't know how to count. A second big issue that I see with these ULAs is that the customer expects that they're going to increase their licensing usage, so they buy a ULA that's based and priced on an increase in usage, and then at the end of the term, the client then certifies. At the end of the time, the client still certifies a usage, but it's a lower amount, and the client then did not really get value for the licenses that it paid. It's equally challenging when the client expects to deploy something into production during the ULA period. So the client uses the ULA as an opportunity to roll out a new system or a new platform, and then for whatever reason, changing business priorities or other challenges that come up during the development of a particular product, the client doesn't have an opportunity to actually ever deploy the product in production, and so therefore it has prepaid for its large environment, and it didn't actually get any value from that. So that is, those are some of the challenges that my clients face. The other issue that I'm encountering is that you can have a ULA that's limited to certain products, but you can also get audited for your use of other products during the ULA, and sometimes my clients are struggling just a little bit with how they are going to tackle the existence of the relationship as it relates to the ULA with respect to potentially a dispute that they're having over other usage. All right, so with respect to the unlimited license agreements, it's important to remember several priorities that you should consider. One of them is that if you're considering entering into a ULA, consider whether it is important for you to evaluate what your actual prospective use is going to be. And the way I typically advise clients to handle that is if you are going to use the ULA as an opportunity to expand your Oracle platform, that you take the time that folks are giving you for how long it will be to develop these products that are not yet into production and double it. So if they're telling you we're going to get up and running in 18 months and you're about to sign a 3-year ULA, think about that very carefully, because it is often the case that these projects are running very long, they're behind schedule, and there are unexpected hurdles to overcome during the deployment process. Secondly, make sure that you are evaluating the terms of the unlimited license agreement very carefully and determine whether or not, if during the term there's a major business change, whether that should be included or excluded in your ULA. So for instance, if you've paid for a certain number of licensing rights as part of your ULA, and during the time of the ULA or the ULA period, you acquire a new line of business that doubles your ULA usage, but the acquisition of a new company or line of business is not an event that's contemplated in your ULA agreement, then you will have trouble with compliance for that particular line of business if it's not expressly allowed within the license agreement. So if you're evaluating a ULA, you definitely want to make sure that you are covering all of those likely bases, that you have visibility into how the products are going to be used and how the environment might evolve. And I realize that you don't always know that. The people who are negotiating the ULA terms with Oracle are not always privy to all of the potential or proposed transactions that are going to occur within the 3-year period. So it is important that if you're in that situation where you don't have that kind of visibility, you at least negotiate as much flexibility into the ULA as possible, so that if one of those unexpected occurrences does come to fruition, you have at least an opportunity to argue the different type of one of the different provisions covers the situation that you have. I have a question. Is the ULA certification based on usage or based on installation? And there is a little bit more information on that, on these questions. But for that one, it depends. You have to read the requirements in your ULA so that you know exactly what you're certifying for that particular product that you have installed. So if you want to make sure that you are doing it correctly, and it's even more important from my perspective to make sure you read it at the beginning so that you know exactly what you're going to be certifying. And sometimes it is the case where clients are actually going through and keeping track of the licenses as they go now, because what many of my clients found is that the expiration of the first 3-year period where the ULA began and served its course and then expired, the clients found that they were trapped into renewing because they had to make a certification and they weren't confident in the certification. So they felt like they had no business choice but to certify the number that they thought was accurate and then re-enter into a new ULA, even though it didn't necessarily make business sense to do that because they felt uncomfortable about the ability to track the licenses. And so many customers in that scenario are finding that if you just continue to track the licenses as though you had to buy licenses for all of them now, it turned out that it was more manageable and it wasn't a huge time crunch or resource drain at the end of the ULA period. As I mentioned earlier, Oracle acquisitions are somewhat challenging. Oracle likes to change the licensing metrics after it acquires a product in many instances. The clients are finding out, both for existing Oracle products and for new Oracle products, that when, or newly acquired Oracle products, I should say, that when Oracle wants to, it can often change the licensing terms, and those new licensing terms will apply as soon as the client uploads or installs an upgraded version of the license. And so with the changing licensing models and newly acquired licensed products, Oracle is often changing its pricing as well. And it is sometimes a big surprise when you find that a product that you've been licensing a particular way for a very long period of time is suddenly much more expensive than it has been in the past. And so just keep an eye on the Oracle acquisitions and recognize that when Oracle acquires a product, there is typically at least a licensing metric change, even if it's not a significant one, and also they consider whether or not they want to change the products as well. The remainder of my time this morning or this afternoon, depending on where you're located, is going to be dedicated to Oracle audits. We have, as I mentioned, seen increased Oracle audits, and additionally, I've seen a significant and substantive change in the way that Oracle is conducting these audits. When I worked with clients many years ago on an Oracle evaluation, Oracle would ask the client to complete a data request, would reach out to the client, would work with the client and insist that Oracle wasn't trying to get revenue for products that were installed but not necessarily used, or for user groups that were not necessarily using the products. And over the last few years, I've really seen that attitude from the Oracle licensing specialist change to more of an adversarial encounter with the customers. When a customer receives a notice from Oracle that Oracle is planning to conduct an audit, then the customer should expect that this audit is either going to be conducted by one of the big accounting firms like Deloitte or Ernst & Young or KPMG, or it's going to be conducted directly from the Oracle License Management Team, or LMS. Whether there's a third-party auditor, LMS representatives will likely participate in the audit, and sometimes if you elect to retain counsel to guide you through the audit, Oracle will also send its counsel to the conferences and other discussions related to the Oracle discussions. In Oracle Licensing and Services Agreements, or the OLSA, there is almost always a provision that allows Oracle to audit the customer as long as it doesn't unreasonably interfere with the customer's business operations. The definition of what constitutes unreasonable interference is certainly hotly contested in the audits that I've been working on with my clients. I can tell you that what Oracle considers to be unreasonable interference and what my clients consider to be unreasonable interference are definitely two totally different things. I do have a question that asks if we're going to get a copy of the slides at the end, and you certainly can get a copy of the slides. If you would like to email me, and my contact information will be at the end of the presentation, I'll be happy to make sure that you get a copy of the slides. So back to Oracle audits. Typical Oracle license agreement will require a customer to respond to an audit. So let's talk a little bit about the audit process and how it works. Oracle will send to the customer an Oracle Server worksheet. And the Oracle Server worksheet is a questionnaire in an Excel spreadsheet typically that the customer is expected to complete with various information, including the name of the machines that are in question, the Oracle products that are in question, what version it is, how many people use it, whether it's physical or virtual, what the configuration is, and a number of other detailed questions about the environment and how the products are set up, used, negotiated, and deployed in the customer's environment. Many times, Oracle will also ask the customer to conduct a validation process where the customer is required to either submit to Oracle scripts or otherwise produce documentation that demonstrates how the products are being used. Sometimes Oracle also asks for you to go and run particular reports in various products to determine, for instance, the number of users or the number of connections to that particular product. So what you'll find is the beginning of the process where Oracle is asking, or the auditors are asking the customer to fill out a spreadsheet, is maybe not that onerous, but then when Oracle moves to the validation process, then Oracle will often ask the customers using Oracle products for reports or results of scripts or other items that are maybe not as acceptable to the customers. A couple of the issues that I'm seeing is that when Oracle asks for these scripts or reports or other items, it is difficult for the customers to determine whether or not confidential or protected information is included in the results. So for instance, Oracle scripts may be masked when you look at the text file output. And when you review that output, it is difficult to read it. And Oracle has a position when it's talking to its customers that, you can read what the script is asking for, and we're not asking for confidential information. So it's not important for you as a customer to determine whether or not any of that confidential information is actually included in there. It is merely important for you to see that we're not asking for it. And as you can imagine, not all of my clients are comfortable with that discussion, and many of my clients are in a position where they would really prefer to conduct the validation process using a non-Oracle script or a non-Oracle tool, and in some instances are in a position where they have to refuse to provide the Oracle output to Oracle because it just simply can't confirm what is included in the text output. When that happens, Oracle is typically understanding and considerate of the concern, but Oracle's response is typically not something that will solve the problem, because Oracle will tell the client in an application environment especially that the client is responsible for tracking use. And if the client doesn't want to use Oracle's tools for tracking use, then the customer must have some other way to track that usage. And can the customer provide a solution that is acceptable to Oracle? Many of my clients cannot provide an alternate solution because, frankly, they haven't been tracking this usage in a good deal of time. And so it is often a give and take during the Oracle audit for my clients to find a way to give Oracle the information it needs to confirm that the client is using the Oracle product in an appropriate way, which Oracle has a right to do, and still protect its customers or clients or usage information from an unreasonable or an improper disclosure because they're not able to review the file output before it's sent to Oracle in a meaningful way. The other audit surprises that I see is now Oracle is in a position where it does not seem to take into account actual usage of the product, whereas historically Oracle has been more understanding about groups that were inadvertently set up or groups that were improperly set up by a third-party consultant. Now Oracle's out of the gate position is if there was a usage or an authorization, I should say, if there was an authorization for a particular user group, regardless of whether they used it, that would be included in a compliance finding. Another troubling trend that I've seen with Oracle lately is that previous agreements or communications with Oracle are not really being honored. And one example that I have of this issue is one of my clients was recently in an Oracle audit. It had a writing from Oracle saying that a transfer of licenses from one of its subsidiaries to another subsidiary was appropriate. Oracle sent my client a transfer of license form. My client signed it and returned it to Oracle. And during the audit, Oracle claims that it never signed the transfer of license form, and therefore that licenses were not transferred, and that there was a compliance gap due to the fact that the licenses were not transferred. Even though we had a number of writings from Oracle stating that the licenses were transferred, and even though Oracle accepted maintenance payments going forward from the transferee instead of the transferor. So it is not the case that we have a court decision on the outcome of that particular issue, but in that situation, my client was very surprised and disappointed to learn that Oracle was not going to stand behind its communications because we didn't have a written, signed by Oracle copy of the transfer of license document that Oracle confirmed that they received. And so you definitely want to make sure that if you're not in an audit situation and you have a transfer of license agreement or other writing, it needs to typically be signed by both you and Oracle, and it's important to make sure that you close the loop on those document reviews and those agreements, because without a signed copy, you are going to potentially be into trouble. The other issue that my clients find is that Oracle's position is it wants to treat all of its customers fairly and consistently, and that if it has a compliance finding, it is not interested in your explanation of the compliance finding. It does not want to make a factual exception for any of its customers. It will consider making an exception on pricing at some point. But in an audit situation, if there is a right or a benefit that is not included in your OLSA, or if you have an older agreement with Oracle, like many people do, your SLSA, Oracle will not give you credit for those licenses, and it's typically a big surprise where people have considered the historical usage of Oracle and Oracle's knowledge of its use case to be compliant, but fails to take that final step in getting the use cases approved and documented, and most importantly documented by Oracle. People are finding that because it's not written down and it's not reflected in any of the documents, Oracle will take the position that regardless of whether Oracle's representatives knew how you were using the product and said it was okay for a long period of time, that going forward it won't be okay. Additionally, during an audit, what I find is there are some items where a certain use does not require a license, for instance Java, but a different use does require a license, and it is confusing and difficult for my clients to determine where that line is supposed to be drawn. And so people are getting unpleasant surprises when they learn that they have to pay for a certain use of the licenses that everyone else gets to use for free, and it's sometimes a little bit of a disappointment. The biggest issue that I'm seeing right now in an Oracle audit is that the termination provision comes into play much more frequently than people expect it to. The termination provision says that if the customer does not follow all of their requirements or otherwise breaches the license agreement, then Oracle can terminate all of the licenses that are subject to that agreement. In many instances, I have clients that have SLSAs that are 20 years old with Oracle, and Oracle can sometimes take the position that if you're not cooperating in an audit, and by cooperating, Oracle means if you don't pay them everything they ask you to pay them within 30 days of the day that Oracle issues its compliance findings, then you are in breach, and Oracle is then entitled to terminate your licenses. So how this plays out is my client will go through an Oracle audit with Oracle for about a year, maybe more. Oracle will do all of its data collection, all of its analysis. It will make a compliance findings or a compliance summary, and it will present the summary to the client. And during that discussion, which is sometimes in person and sometimes on the phone, during that discussion, Oracle will then say, we have found that there are a number of instances of noncompliance, and here are these identified instances that we found, and here's how much we want you to pay. I can tell you it is never the amount that my client expects it to be, and it's typically more than they expect it to be. So let's just use a hypothetical number today of $10 million. So Oracle comes to the client and says, we found a number of license deficiencies. We found a number of areas where you were using the products outside the terms of the license agreement. We found a number of instances where one subsidiary was using licenses that that subsidiary was not entitled to use. And we found many instances where some products in a product family were being used and maintained, and other products in that product family were not subject to maintenance. And so you owe us back maintenance on all of the licenses that were not maintained that were in the same product family as a license that was maintained. Then Oracle says, you owe us $10 million, and we would like that check 30 days from now. The clients go back to Oracle and say, we object to your compliance findings, and here are all the objections that we have to your compliance findings, and these are all of the legal and factual reasons that we object to your compliance findings. And we do agree that there's an issue, and we do agree that we should have to pay for that issue. But our estimation of the amount that we owe for the compliance gap is significantly less. Let's pick a number, $500,000. We want to pay you $500,000. And the negotiation begins. So Oracle will, in some cases, entertain a reduction off the opening number. But when they get tired of negotiating, Oracle will just come back and say, it's been more than 30 days. You were supposed to pay within 30 days. Pay right now, or we'll terminate your licenses. Another thing that Oracle will do is, at some point in the process, usually after you receive your compliance findings, but before you reach final resolution, Oracle's sales team will call and say, this is the sales team. You really don't want to have to deal with the license management team. Let us help you take care of this. Come over here and talk to us about a sales resolution so we can work at this on a business level rather than on a compliance level, because once it gets back over there, you are maybe going to have a little bit of a trouble getting a resolution that you find appropriate. So in many instances, my clients do find that the sales team is easier to work with, but in most instances, what's happening is the clients don't agree with the original client's compliance finding. And because Oracle is not entertaining a discussion of the underlying facts past the interpretation that's present in the OLSA or the ULA or the ordering documents, then the clients are really stuck in a position where the starting number is too high and they feel like they're not required to pay whatever ending number it is that the sales team is negotiating. This is particularly difficult for customers that are in the middle of a transition or a migration when the audit occurs, because the licenses are required to be licensed in a development or testing environment, and many people don't realize that if you're in the process of moving from one server to another, Oracle considers that two usages, and typically people have to pay, and Oracle would require you to pay for that twice, at least during the term of the migration or the transition. And so for folks that get caught during the middle of a migration, then Oracle will say, you owe us twice for each of these licenses because they were in two environments. And the customer really feels like that's unjustified, but doesn't have a lot of opportunity to overcome that objection. So it is important when you are entering into a relationship, and you have to do this at the very beginning. And so for those people who already have 20 years worth of paperwork with Oracle, it's going to be a little bit difficult. But if you're in the process of updating or modernizing the license agreements that you have with your software vendors, check the termination provisions. Most software publishers, not limited to Oracle, most software publishers have these termination provisions in their agreements that give them the right, if they say you're in breach, to terminate your license use. And I can tell you that a purported termination of a license agreement is typically a guaranteed fight in court. So you don't want to have a situation where your two options are potentially violate the Copyright Act by continuing to use licenses after your license agreement was expressly revoked, or go down to the courthouse to fight with Oracle about whether or not you can use the products pending the determination of whether you violated their licensing terms. As you can see, those really aren't great options either way, and so it's important to make sure that you understand what those termination provisions say and what they mean when you enter into the license agreement, and see if there's any wiggle room or opportunity for you to negotiate maybe slightly better terms in the end. Today we've talked about some of the challenges to licensing and Oracle acquisitions, and also some of the issues that come up in an audit. So how do you try to minimize those risks? I would say the number one thing that I would tell people when they're considering making changes to their Oracle environment or establishing a new Oracle environment is understand what you're doing when it comes to use cases, license requirements, and virtualization. People really get in a bad situation by not understanding the licensing requirements for virtualization. And sometimes it's unintentional because this product's been in the environment for a number of years, and Oracle treats virtualization differently than the old publisher, and it can really be difficult to identify those challenges before they become an issue with Oracle. Make sure that you're looking at your Oracle license position regularly, and also make sure you understand how Oracle would look at it. I have a number of clients who have come to me over the years and said, we're good. We looked at it, we understand it, we're good. And then Oracle comes along and says, not so fast. You're not as good as you thought you were. So make sure that you are regularly evaluating it and that you know how Oracle would look at it. Not saying you're not doing it right. I'm just saying if you have a difference of opinion with Oracle on how to interpret it, outside of a court case, Oracle's interpretation is going to be the one that they rely on. And if you're not cooperating, Oracle can and sometimes will threaten to terminate the license. Make sure that you're working with people who understand how Oracle is going to treat those licenses when you are trying to negotiate new terms or reevaluate your Oracle environment, and then make sure that if you're going to rely on those licenses or licensing answers, and if they're coming directly from Oracle, that you get it in writing and signed. An email is not going to be good enough. And finally, and I can't stress this enough, your resellers very well may have your best interests at heart, but they typically are, not going to be a way for you to convince Oracle to reverse findings of non-compliance, and B, are not going to take the bullet for you when you have a licensing compliance issue in the end. So time after time, I've seen resellers give advice on how the licensing is supposed to go, then even Oracle certified partner resellers will give advice. When the advice is wrong and the customer is assessed a penalty in the compliance findings of an audit, then the customer goes back to the reseller and says, Oracle made me pay $2 million for this, and I did it because you told me to. So I want you to pay me for this bad advice you gave me. And the reseller says, oh no, I was only supposed to execute the order you sent me. I wasn't supposed to tell you how to license your environment, so we're not going to be involved in your dispute with Oracle about the licenses that we told you to buy. So just beware of those situations. I see them happen a great deal of time, and it's definitely something that you want to avoid if at all possible. That is all the time that I have for today. I really appreciate everybody attending the informational session today, Oracle Software Licensing. This is Julie Mockle-Foltz from Scott & Scott. I'm going to pass it back to Anita to give the information about the Texas bar number. Anita?